Hello, can you all hear me? Hi everybody, good evening. How are you all? How are you all? Good? I'm good, Sunil. Okay. Good evening, Praveen. How are you? Okay. So, let us just. I'm good, Praveen. I'm fine, absolutely fine. So, let us just start with the class. Let us get on with it. So, today we are going to discuss about some of the important documents which we find of great use when we are talking about formation of a company. Okay. So how many of you know about this word? How many of you know what is this? MOA. What is this? MOA. What is this MOA? Yes, Memorandum of Association. So Sunil, what is this Memorandum of Association? Is it some kind of like a medicine or a mobile or a brand of laptop? What is this Memorandum of Association? What is this actually? Prabhavati, Maria, Suvit, how are you all? You are late by 5 minutes. Okay, Maria, is it your first class? And Suvit, yours also? I'm seeing you for the first time. Okay, this is your first class. Alright. So today we will be discussing about Memorandum of Association, Articles of Association and some other related topics. Alright. So let us just see what is Memorandum of Association. Then I'll explain you. Like if you go to a school, then if you want to admit your child to a school, or if you yourself want to take admission in a college, then how do you know whether this school or college is a good one? How do you come to know about it? From where do you get the feedback? Yes, from where do you get the information? From where do you gather that information? That information comes to you from the prospectus of the organization. Prospectus. It is a document which gives us information. Okay? So that we'll be discussing about prospectus in the later part. Right now we'll be discussing about MOA, that is Memorandum of Association. Good evening, Piyo. How are you? So we can say that Memorandum of Association of a company is its charter and defines the limitations of the powers of a company. It contains the fundamental conditions upon which alone the company is allowed to be incorporated. Means it is the governing document. It lays down the premises in which the company is supposed to operate and work. Okay? It defines the parameters or the boundaries for the company. So Memorandum of Association is the legal document which a company forms, and this document helps in the normal functioning of the company. It governs the normal functioning and working of the company. The company is not allowed to violate the rules and regulations given in the Memorandum of Association. If it does so, its license may be cancelled. Okay? And Memorandum of Association is a document which is issued by a public limited company. A public limited company is a company in which the people invest their money and they get shares in return. Okay, so the shareholders are the real owners of the company, and those shares are held by the general public. That's a public limited company. So if we have to define a Memorandum of Association, we can say it is a Memorandum of Association of a company as originally framed or as altered from time to time in pursuance of any previous company's law or of this act. You know, every company, it is formulated under the Companies Law 1956. So Memorandum of Association is one document which every company needs to form at the time of its formation. Okay? Is it clear to everyone? Praveen says yes. Prabha says yes. Suvit says yes. Rezi says yes. Maria says yes. Okay. So, what is the basic purpose of Memorandum of Association? Memorandum of Association is like it has all the information about the company. Yes, it has got the information about the company, and it also lays down the boundaries in which the company has to operate. Okay, so how much, what activity is legal or which activity is illegal, that all can be assessed with the help of the Memorandum of Association of a company. Alright. So the purpose of Memorandum of Association is to enable the shareholders, creditors and those who deal with the company to know what is permitted range of enterprise is. And this definition is given by Lord Macmillan. So it basically lays down the boundaries in which the company has to work and operate. So what are the forms of Memorandum of Association? Means since it's a legal document, it has to be laid in a legal manner. It cannot be published just like that. It has to follow the format laid down for it. So it has got forms as given in tables B, C, D and E in Schedule 1 of the Companies Act. Then it's a printed document. It is divided into paragraphs. It is numbered consecutively and it has to be signed by at least 7 persons for public limited companies and for 2 people in case of a private limited company. And these signatures should always be attested by witnesses. Okay? And those who are subscribing to the shares of the company, they must at least hold 1 share of the company to claim their ownership or to claim that they are the shareholders of the company. Alright? So you have to remember this is a very important point. It should be signed by 7 persons in case of a public limited company and by 2 people in case of a public limited company. Is that clear to everybody? No PU, it cannot be more. This is legally not permitted. Sorry, it can be more. Like 7 is the minimum number. It can be more than that. But at least 7 people have to be there who have to attest it, who have to put their signatures. They are the witnesses. We can, they are like not the witnesses. Witnesses are other people. So what are the main contents of a Memorandum of Association? There are 6 main clauses. The first one is the name of the company. That's very important. What is the object? This clause will hold the name, like what is the name of the company, that has to be clearly mentioned here. Then date of formation, name and other details are mentioned. Object, with what purpose has been the company formed, that will be in object. where since it's a company, it will have a registered office of its own. Since company is regarded as a legal person, it has got a separate legal entity of its own. So since it's a separate person, it's a legal person, so legal person will have his own legal address also. So that legal address is the registered office of the company. Okay? The place where the company, from where the company operates, that is the registered office of the company. Then liability. You understand the meaning of liability? Okay. Payables, outstanding. So the company has a liability of its own. So liability. Then capital. Capital, what is capital? Is it capital of a country? Am I talking about capital of a country? Like if the company is located in India, its capital is in Delhi. So is this the meaning of capital over here? No. Capital actually means the investment. Yes, the investment that has been done to initiate the company, to start the working of the company. So capital is divided into different classes. It is working capital, called up capital, paid up capital. There are different classes of capital, and that is being that all is being mentioned in the capital clause of the memorandum of association. It will have all the details. Like it can say that the company has a total capital of 50 crore. The company is called up capital. Called up capital means the, you know what is called up capital? What is called up capital? Put up, registered. No, not exactly. Called up capital is like, now suppose if the initial investment in the company has to be of 10 crores. Now what is the company going to do? There are two options. Either the company, the owner of the company is going to invest his personal funds, but raising an amount of 10 crore is really very difficult. So in this case, what the company will do? They will make up shares of small value, and they will, yes, shares. They will raise the money through shares. They will issue shares to the shareholders, and those shareholders are the general public. So that general public, Prabhavati, don't mind. I understood what you are trying to tell. It's shares. So that money will be paid by the general public, and that will form the capital. So called up capital is like, suppose the value of share is 10 rupees. In that 10 rupees for one share. Okay. Now what the company might do, they might just ask the people to invest 3 rupees initially, to send 3 rupees only. 3 rupees means if a person is taking 100 shares, then he will pay rupees 300. So that 300 will be the called up capital. Okay, they have called up for 3 rupees. Now out of that 3 rupees, some people might just pay rupees 2. Some people might just pay 1. So that 1 and 2 will be regarded as the paid up capital. 1 rupee, 2 rupees paid by them will be the paid up capital. Okay. So in prospect of company, we'll talk about total. If suppose the called up capital is 10 crore and paid up capital is 7 crore. So that is, there is a difference of 3 crore. That 3 crore will be called upon by the company later on when it will need the money. So that all details are mentioned in the capital clause of the memorandum of association. Okay. Then association or subscription, it like shows the details about the people who are associated with the company. We can say it contains the details about the promoters. Who are promoters? Promoters. No, Prabhavati, they are not the shareholders. Shareholders and promoters are two different people. Who are promoters? You know that? Shafan is writing, that supports. Okay, promoters are actually the people who conceive the idea of forming a company and who make all the necessary steps to to set up the company, and then in the initial stages they are the people who promote their company. They work day and night to promote their company. So they are called promoters. Okay? They are regarded as the promoters. And yes, initially they do the marketing for company. And shareholders are the people who just purchase the shares of the company, and by purchasing the shares of the company, they get ownership rights of the company. Okay? And the company is governed by who? Who governs the company? Can you tell me that? The policy framing and everything. Who does that? CA? No, Sunil. Not exactly. Chartered accountant just looks after the financial aspects. And he is an employed servant of the company. He is not like the decision maker. Can anyone tell me who governs and manages the company? The company is managed and governed by BOD. Yes, Board of Directors. Board of Directors is the body which governs the company, which plays a role in policy formation. Okay? So it might just happen that some of the promoters may become Board of Directors also later on. Shareholders just have a like ownership of the company in the form of the shares. It's just like that. People buy shares of the company from the prospect of investment. Like suppose if the company is doing good, they might just buy the shares at ₹10, and with the course of time, just the value of ₹10 share may go up to 1000. So they have a clear-cut profit of 990 rupees in one share. So that is the people buy shares just from the point of view of investment. Okay? They are not they don't have anything to say in the working of the company. They just invest in the company. And company uses the money received from them. So it uses this. No Praveen. Founder of the company are the promoters. And board of directors are different. Board of directors is the governing body. In the board of directors, we may have some lawyers, we may have some CEOs, some members of the family of the promoters. That is altogether a different team. Okay? Founder of the company and board of directors are different. They are not one and the same. Alright. So now doctrine of ultra vires. What does this say? It means ultra means beyond, virus means the power. So ultra virus means beyond the powers. Now what is the significance of this? A company which owes its incorporation to statutory authority cannot effectively do anything beyond the powers expressly or impliedly conferred upon it by the statute or memorandum of association. Yes, whatever is written in the memorandum of association, that has to be followed word by the company. Company cannot make changes in its policy as per its own whim and fancies. They have to operate on the principle of ultra vires. Ultra vires is within the foundations or the rules laid down in the prospect or in the memorandum of the company. All right. Now here is a case. the company has been formed. The details of the case are Ashbury Railway Carriage and Iron Company Limited, Wyridge. So company has been formed with the object to make and sell or lend or hire railway carriages and wagons and all kinds of railway plants to carry on the businesses of mechanical engineers and general contractors, etc. The company contracted with Rich to finance the construction of railway line in Belgium. The company repudiated the agreement and was sued for the breach of contract. Okay, this company was Ashbury Railway Carriage Company. It was involved in a public dealing. It was into the business of railway carriage and all. It was a big investment business. So we can say it was a public limited company, and they must have had their memorandum of association, and Ritchie was one of the contractors, one of the financiers. So what did the company do? They did not follow the rules and regulations of the agreement. So they were sued for the breach of contract because they did not follow what was written in the memorandum. Then what happened? Firstly, that the contract in question came well within the meaning of the word general contractors and was therefore within the powers of the company. Secondly, that the contract was ratified by the majority of the shareholders. How was this company how was their query settled down? It was like the company had in the memorandum general contractors word was mentioned. So whatever the issue was, it was sorted under this category. And secondly, the contract was ratified, means it was changed by the shareholders of the company. So what are the effects of the doctrine of ultra vires? Means what are the impacts of this doctrine? First, void ab initio. It means void at the very beginning, void or null at the starting. Means this holds no legal importance. That is the most important point. Then personal liability of directors, acquisition of property, that is ultra vires, and directors personally liable to third parties. Holding the position of director of a company is not an easy job, because director of a company is also personally, sometimes he becomes personally liable to the third parties for the settlement of claims. In case the company becomes a bankrupt and all its assets and properties are sold off, then in that case even the director's property may be treated as a part of the company's property, and it may be taken into account for the settlement of claims. Hello, Prabha, can you hear me now? Prabha, can you hear now? Hello, Prabha, can you hear me? Okay, she is offline. Alright, now if we have to make a change in the name clause of the company, if we have to change the name due to some reason, then a special resolution has to be passed. Written approval of the central government is needed. Then no approval of central government is necessary if the change of name involves only the addition or deletion of the word private. Change by ordinary resolution and approval of the central government when name is identical or too closely resembles the name of an existing company. Okay? So only if there is a significant change in the name, then we need to have a special resolution. If it is a minor change, then that can be done by passing an ordinary resolution itself. Now change of registered office. If we have to change the registered office of the company, then what we have to do? If it has to be shifted, we have to pass a resolution. Board of directors will have to pass a resolution. Okay. and the regional director has to be informed about it, and copy of this resolution and intimation to the regional director has to be given with the registered office of the company, means the authority. Registrar of companies, ROC is the registrar of companies. He is like the authority who looks after the working of the into the formation and working of the companies. So registrar of the companies, he should be informed about it, and notice of new location should be given within 13 days. Once we have shifted, then within a period of 30 days we have to inform the registrar of the companies about the change in the address. Okay? Clear to everyone? Sunil, Muhammad, Suvit, now can you just tell me one thing? How many people need to sign a memorandum of association in case of a private limited company? Can you answer that? How many people are needed to sign that? Piyu says 2. Sunil, what is your answer? Prabha says 7. Mohammed says 7. Suvit says 7. Praveen says 7. Sunil, Rezi, Maria, 7. Rezi says 7. Okay. This is for those who said 7. You did not mind my words. I said yes, public 7, private 2. I said private company. So right answer was given by just one person. Who said that? 2. That 2 was said by Piyu. So this is for Piyu. Piyu is applauding himself. That's funny. Ha ha ha. And then within how many days registrar of the company must be informed about the change of location of the company office? Is it 1 month, 2 months, 3 months? 30 days. Yes, actually it is 30 days or 1 month. Now if the change is from one state to another state, then it can be affected by passing a special resolution. Now who is going to pass this resolution? Who is going to pass this resolution? The shareholders? The promoters? Prabha, registrar of companies, not at all. He is the authority who needs to be informed about everything. So special resolution will be passed by the shareholders or the directors or the promoters. Who is going to pass it? Directors. Yes, it has to be done by board of directors. Then approval from central government has to be taken, and it is allowed for certain purposes only, not in every case. So you see, if the change of address is just within the same city or same town, then we don't need any approval from the central government, and by passing an ordinary resolution we can do that. But if it is an interstate change, then special resolution has to be passed and government approval has to be taken. Now, alteration of the object clause. What are the situations in which we can change the object loss. These are the reasons behind it. Okay, you can read it after a while, after the class, once you get the PPT. And first step is passing the resolution. Second is seeing that the resolution is brought on these grounds. And the third is copy of the resolution submitted with the registrar of the company within 30 days. Now, alteration of the liability clause. The liability of a member of a company cannot be increased unless the member agrees in writing. Obviously, who will want to take more liability, more limitation? Nobody wants that. So, if they agree, then only this can be done. And from unlimited liability, it can be made limited by re-registration of the companies. Sometimes, when the companies are initially established, then the liability of the shareholders is unlimited. But with the passage of time, what is done is that the liability is changed to limited liability, and that is done by the re-registration of the company. Okay? Everyone? Now the next clause was the capital clause. Now how can this be altered? Increase of authorized share capital, consolidation and subdivision of shares, conversion of shares into stock and vice versa, and diminution of the share capital. Means share capital can either be increased or decreased, or these changes can be affected. Division of the shares and conversion of shares into stocks and all. This can be done. That is when we need to affect a change in the capital clause of the company. Now, this was about Memorandum of Association. Now next is Article of Association. This is the term. Maria, is it clear now? Can you hear me properly now, Maria? Okay. So, a similar term is Article of Association. Now what is this article? It says it means the Articles of Association of a company as originally framed or as altered from time to time in pursuance of any previous company's laws of this Act. Let's go to the other one. You know, Article of Association is that document which is normally filed by the private companies. It is very much similar to public limited companies, the Memorandum of Association, but it is an article which is filed by private companies. And if in case if we are not able to file a Memorandum of Association, then in that case we can file an Article of Association. Okay? It's a substitute of that, we can say. So what are the contents of Articles of Association? These are the contents that can be read by you later on. Now, if there has to be any change, how can that change be? Prabha, Memorandum of Association is a wider term and it is applicable in case of private limited companies. Article of Association is a miniature of the same and it is normally used by the private limited companies. And in case we are not able to file a Memorandum of Association, then we can go for Articles of Association. Okay? Now if we have to bring about changes in the Articles of Association, it can be done by passing a special resolution, copy of resolution to be sent to registrar within 30 days, Copy of altered articles to be registered within 3 months of passing of resolution. These are all technical details, but you need to know. Now, what are the limitations regarding the alteration? First, it should not be inconsistent with the provisions of the Company Act, means it should be within the boundaries of the Companies Act or the conditions contained in the memorandum. Approval of government to be obtained. Alteration must not deprive any person of his rights. Alteration must not constitute a fraud on the minority. An alteration must be bona fide for the benefits of the company as a whole. Now, what are the binding forces of the two? Company is bound to its members. Each member is bound to the company. Each member is bound to other members in the exceptional case only. And neither the company nor the members are bound to the outsiders. Okay. This is the legal implication of this Memorandum of Association and Articles of Association. Alright. Now you can see the difference between the two. Prabha, this is a very good slide for you. Memorandum is a charter of the company and article is mainly meant for the internal management. Memorandum, it defines the scope of activities. This defines the rules for carrying out the objectives of the company. It's a supreme document. It is subordinate to the memorandum. This is must for every company, and company limited by shares need not have it. Yes. Strict restrictions, alteration only with sanction of government, can be altered by special resolution. Act ultra virus is wholly void and cannot be ratified. Act ultra virus but intra virus memorandum can be ratified. Means anything which is done is wrong as per the company's is like if it's within the boundaries of the Memorandum of Association, it can be ratified. But if it is outside the Memorandum of Association, then it cannot be ratified and corrected. If it's outside the Memorandum of Association, then it is also illegal as per the company's law. So it cannot be ratified. Okay. Now, doctrine of constructive notice. What does this say? This says documents are open and accessible to all. Presumptions that any outsider dealing with company has read and understood the documents, and it is a negative doctrine, acting only against the outsiders and not the company. Yes, we believe that if someone is now coming to deal with us, then they must have read the policy of our company, and they must now be they must have really accepted it. Only that is why they are dealing with us. But this is a negative document because it only supports the company and not the other party. Now, what does the doctrine of indoor management say? Doctrine means the principles. Okay, so the principles of indoor management says a person dealing with the company in good faith have a right to assume that the internal requirements prescribed in public documents have been observed. The persons are not bound to inquire into regularity of internal proceedings. Means if the memorandum of association, if a company is having a memorandum of association, then it is assumed that the company is a legal company, it has followed all the rules and regulations, and we can deal with it. Okay, like that trust is there. So this brings us to the end of this memorandum and articles of association. Any doubts, anybody? Anyone want to ask anything? No, Prabha, they are not exactly the disadvantages. These are the exceptions. Means these things are not covered under the these principles. like knowledge of irregularity. If any employee is misbehaving, then that is not something that can be covered under the the memorandum or the article. It is something for indoor management to check and find out. Okay. Now we go to, it is same all over the world or in India. It is more or less the same field. It is the same. The rules are more or less the same. There might be some changes in some clauses or some acts, but more or less it is the same. Basic structure is the same. So after doing memorandum and articles of association, the next important document which is very important in the formation of the company is the prospectus. So prospectus, as we know, it is a document which gives a glimpse to us into the insides of the company. Like suppose if we want to take admission in a college, then what do? We go through the prospectus of that college. It has got all the details about the fee structure, the timings, the pattern of classes, then the details of the faculty, the number of years it has operated, the type of events it has held in the past, along with the photographs. So all the details are there. So it's like an introductory document, a document which gives us an introduction to the company. So similarly, prospectus of a company is a document which gives us an introduction about the company. Okay? If you have noticed, like whenever you see an insurance ad on the television, there is a line added there. Can anyone tell me what is the line? An additional line is put in insurance advertisements which are flashed on television. What is that line? Yes, read the prospectus. Exactly, Suvit. So, prospectus is something which gives us an insight into the company. So that is why it is a very important document. Memorandum and article of association are the two legal documents, and they are the documents which are framed before the formation of the company, and they need to be submitted before a company comes into existence. They need to be, yes, Piyu, that is our fault that we never read it. Memorandum and articles of association are the documents which are submitted with the registrar of the company. Like they are the technical documents. But if we are going for public dealing, if it comes to common public, how is the common public going to know about the company? That information is given to us by the prospectus. Okay, how much shares we have to buy of this company? Do we have to invest in it? That all information we can get through the prospectus, through the details mentioned in the prospectus. So what is the legal definition? It's a document described or issued as prospectus and includes any notice, circular, advertisement or other documents inviting deposits from the public or inviting the offers from public for subscription on purchase of shares or debentures of the company. So this is the basic purpose of a prospectus. A prospectus gives us all the details, and then the basic purpose is to just find the prospective shareholders for the company. People come to know about the company and its details, and then they decide whether they have to invest in the company or not. Okay, so prospectus is that document which gives us that detail. Okay, now let us see company prospectus. What is its meaning? What are the legal requirements? Yes, Prabhavati, it is especially in the case of insurance policies, investment plans, because these are something which keeps on fluctuating. Okay, So terms and conditions are subjected to change. So let us see all these in detail now. So it's released by the company to inform the public and investors of the various securities that are available. So these documents describe about mutual funds, bonds, stocks and other forms. Okay, so this is like the legal definition. It is generally accompanied by basic performance and financial information about the company. Now, what are the legal requirements of the prospectus? It is to be issued only after the incorporation of the company. Like once the basic things are approved by the government, yes, it's a good company, it is being formed with so and so intentions, so this can be allowed, its formation can be allowed. Once government is satisfied with all these things, only then the company is allowed to issue its prospectus. Okay. The prospectus must contain all the particulars listed in the Schedule 2 of the Companies Act. The prospectus must be dated. Before a prospectus is issued, a company of it must be registered with the registration of companies. Again, it's a legal document. It needs days of the registration. Okay, that's very important. That time period of 90 days. The registration, that it should be issued in 90 days of the registration. Means once the company gets approval from the registrar, within 90 days this prospectus should be issued. Now types of prospectus, these are the different types: abridged, deemed, shelf and red herring. So abridged prospectus is like the short form of the prospectus. Okay. Deemed prospectus, you know about deemed university, something that is assumed to be. So this type of a prospectus is something which is assumed to be a prospectus. A document assumed to be a prospectus. Then shelf prospectus, this is quite similar to the abridged prospectus only. The only difference is in the detailing. Then red herring prospectus, it is like again a prospectus, but a prospectus with a details in it, lot of details in it, and especially about the like it's normally issued by the insurance companies. The business in which there are wider fluctuations, they are going to issue the red herring prospectus. Okay. Now what are the details in it? Name and address of the office of the company, name of the stock exchange where application for listing is made, date of opening, date of closing, name and address of the company's managers and managing directors. The intricate details are mentioned in case of a prospectus. The basic things. Okay, everybody? Any doubts? Is it clear to everyone? Muhammad, Rezi, Suvit, Maria, Piyu, Rinin, Prabhavati, Giju, Sunil, Praveen, Ramesh. We can say it is just a replica of the memorandum of association only, but the only difference is memorandum is association is. Jiju says that MOA in UA is different. Is it so? It's not so, Jiju. Okay. But like what we are studying is as per the Indian standards, and your curriculum is also based on that only. Okay. So these are the, it's just a replica of the same, but it's a miniature form and it is meant for public dealing. This gives information to the public and memorandum gives information to the government. So capital structure as it was there in that only. Particulars of the issue, like what is, why the share is being issued, what is the cost of project, what are the means of financing, everything. It's taking time in loading. Slide number 10. Can you all see the new slide? Yes, now we can see. Outstanding litigation. Litigation is like the criminal proceedings which are going on. So how much criminal or legal, we can say legal proceedings are going on the company relating to financial matters or criminal proceedings against the company or directors under Schedule 13. Okay. And it is not like, since the company has not been formed, it is not still it has not started operating, then how can we say that there may be some financial matters or criminal proceedings? It is like against the directors of the company, those who are in the board of directors. What is their status regarding these matters, criminal proceedings or financial matters, that need to be considered. Okay. Now certain prescribed particulars. So in regard to the company and other listed companies under the same management which made any capital issue during the last 3 years. So this is the technical issue, that the date on which every prospectus should be dated, it should have a date on it, and if the date is, whatever date is mentioned, it is believed to be the date of publication also. Means it is assumed that the prospectus has been issued on that date to the public only. So another technical aspect is that the copy of the prospectus signed by every director or proposed director or by his agent must be delivered to the registrar on or before the date of publication. The prospectus issued to the public should mention that a copy of the prospectus along with the specified documents have been filed with the registrar. This is important. First, the copy of prospectus should be handed over to the registrar, and then it should be issued to the public, and it can be on the same date itself. A prospectus must not be issued more than 90 days after the date of which a company thereof is delivered for registration. If a company prospectus is so issued, it will be deemed to be a prospectus, a copy of which has not been delivered to the registrar. So there may be some technicalities then. Some problems may crop up if it is believed that the prospectus has not been given to the registrar. A public limited company which has not issued a prospectus, which has issued a prospectus but has not proceeded to allot any of the shares offered to the public for subscription, is required to deliver to registrar a statement in lieu of prospectus. Okay. Means this is like a statement in lieu, in regard of, in place of. So in case the company is not able to issue the prospectus in time, it has not been framed or due to some other technicality, a similar type of a statement must be issued at least 3 days before the allotment of shares or debentures. Allotment cannot be done unless and until prospectus has been issued, because we cannot allow people to invest in a company unless the basic framework of that company is decided. And that prospectus is a document which gives us an idea about the basic framework of the company. So there has to be a prospectus before allotment. Okay, everyone? Now this contains the details of the particulars. In case of private company becoming a public company, statement in lieu of prospectus can be filed. Means suppose it's a private company and now it's converting into a public company. So Schedule 4 contains the details of the particulars to be furnished. And such a statement is required to be signed by every person who is named therein as a director or a proposed director of the company or by his agent. Means signature of the director is very important, because people invest at the trust that this person is their director of the company, then it must be a good company. Like this psychology works at times. So there has to be that proper signature and all. Now, if allotment of shares or debentures is made without filing the statement, the allottee may avoid it within 2 months after the statutory meeting. Okay, if this is not legal, if suppose allotment is made but the prospectus has not been issued, then this fact should be taken into consideration. And it means like if the company may be fined up to rupees 10,000. This is the legal procedure. So this is all like step-by-step technicalities which will. These are the legal technicalities which must be taken care of, and every prospectus should include these things. So you can just study them afterwards once you get the PPT. Alright, I'm not going into details because just a minute is left for the class. Okay, so it's like step by step. So you just need to read them and you will get an understanding of the same. In case any problem crops up, you can ask me in the next class. Alright, so now the class is about to be over. So please don't forget to mention your feedback, and we'll meet in the next class which we'll have on Thursday. Alright, so let us all meet on Thursday. That will be your weekend time. So let's see each other on Thursday. Have a great time till then, and do take very good care of yourselves, and a very good night to all of you. Thanks for your time, everybody. And please don't forget to mention the feedback form. It's very important, and you can fill your suggestions and any queries if you have, you can just mention them there. Okay? In the feedback column. Alright. Thanks so much, everyone.